motion matter my lord, two times left over my lord.
Motion matter left out.
Yes, my lord. Two times, my lord. So tomorrow or day after tomorrow, my lord.
Day after tomorrow.
Obliged.
May I please your lordship, for listing, IA lordship, extension of time to appear before the SP lordship on Thursday lordship.
But make a mention in the morning after being listed. If it is down below or if for some orders
Lordship.
maybe left out. So in the morning you make a mention.
Yesterday listed, but left over.
Is it?
Yes.
You could have said before we have passed an order. Anyway, tomorrow burners, day after tomorrow.
Thursday.
Day after Saturday.
Diploma.
May I please, your lordship? Lordship, I beg to mention item number 5, lordship.
Yes.
Well, lordship, there's some serious matter going on in court number 4, lordship. So that might take some time, but it might continue for 2 to 3 days. So matter may be posted after 2 weeks, lordship.
Have you informed the other side?
Yes, lordship.
Yes.
Mr. Ali, any difficulty? Prepare Council for the Union of India responded.
Date.
How much time? 3 or 2?
Lordship, after 3 weeks.
Give us a fixed date.
Lordship, let it be on 25, lordship, Thursday, 29th, lordship, sorry. 29th.
6th of February.
Obliged, lordship.
Sixth of February. Mr. Ali?
Yes.
6th of February, Tuesday.
Obliged.
By order dated 2012-2023. Foreigners Tribunal's record pertaining to Foreigners Tribunal record being GFT within bracket R, case number 1773/2017 was called for from the office of the London member Foreigners Tribunal Kamrup within bracket real number 1. Office note dated 06/01/2024 reflects that the same has not yet been received. Issue reminder. Release this matter again on
Actually, I'll phone call you.
23rd along with the records of the aforesaid case. Aforesaid GFT.
May I please, your lordship? Your lordship, petitioner in this case has expired on 21/11/23, but we haven't received the death certificate. So I would like pray for adjournment.
What's your good name, ma'am?
S. Das,
Full name?
Sutapa Das. Lordship, I am appearing on behalf of Mrs. B. Gogoi.
MS Sutapa Das, learned counsel appearing on behalf of MS Bonatri Gogoi, counsel for the petitioner. on instruction submitted that the petitioner hearing from the consent proceeding expired on 23rd of December,
21st/11/23.
21st of November, 2023. However, the Land Council yet to receive the death certificate of the petitioner. List again. On 6th of February. Enabling the councils for the petitioner to place the relevant death certificate.
Highly obliged.
May I please, Your Lordship? Lordship, I have filed an IA for correction of order dated 4/8/2023. Lordship. And order at page 9, Lordship, in IA.
Mr. Sharma.
Lordship. Lordship, let the records come because Lordship petitioner cannot go beyond record, Lordship.
No, it is available on record. The WSC claimed that his father named so and so, and the voter list also.
Maybe, but let the record come, Lordship.
For this correction, record is not required, Lordship, and the WSC, everything is available here.
By this interlocutory application. The petitioner prays for correction of the order dated 08/2023. First in the connected WPC number 4396 of 2023. Referred by the applicant as petitioner. Challenging the order, final order dated 23/05/23, passed by learned member Foreigners Tribunal 5th Borpeta Assam. In case number FT within bracket 5th 338 of 2017. Whereby the learned tribunal declared the petitioner as a foreigner under the Foreigners Act 1946 of post 1971. It is contended by the applicant that in the state order dated 04/08/2023, the applicant / petitioner has been shown to be the daughter of Kalimuddin and not Uli Sheikh, whereas Sheikh Kalimuddin is her uncle. From the order dated, from the records of WPC number 4396 2023, connected WPC. It is seen that notice has not yet been issued in the said writ petition. And the relevant records from the concerned Foreigners Tribunal has also not been called for. We have also seen from the order dated 04/08/2023, so para kore likho. First in say WPC number 4396 of 2023. The court, after hearing the parties, observed that the petitioner seeks to give an explanation that the name of Kalimuddin in the voters list up to 1970 appeared as Kalimuddin, and from 1997 onwards it appeared as Uli Sheikh, ULISHEIKH. Considering such observations made earlier by the coordinated bench of this court, we decided to peruse the relevant records in original involved in this case, involved in the connected WPC, and then to consider the prayer made by the petitioner in this application. List after 8 weeks along with the connected WPC number such and such. In WPC number such and such. This writ petition has been filed by the petitioners on 01/08/2023. Being dissatisfied with the order dated 23/05/2023 passed by Agotni Friday. Whereby she has been declared, she. Issue notice returnable by 8 weeks. As Mr. C. Sharma, Standing Council, Home Department, Assam. What's your good name?
Yeah, Ali Lordship.
A. Ali,
Lordship.
full name
Asghar Ali Lordship.
for the petitioner. Mr. Z. Sharma, Standing Council, Home Department. For the restaurant number 2 and 4. Mr. P. Sharma, Additional Senior Government Assam, for the respondent number 3. No representation on behalf of the Union of India, restaurant number 1. Election Commission of India, restaurant number 5. So notice, tenable waiting.
Lordship, we have no interim, so interim may be considered.
As such and such, no problem. Petitioner cells are requisite extra copies to such and such by tomorrow, obtaining necessary acknowledgement. Petitioner shall also serve requisite extra copy of this, including the annexes available. Mr. R.K. Dev Chaudhary, Learned Deputy Solicitor General of India, for the restaurant number 1, as well as Mr. A.I. Ali, Standing Council, Election Commission of India, for the respondent number 5. During necessary acknowledgement by tomorrow, go to work. Petitioner shall take steps for service of notice on the respondent number 6, registered post of duty, providing its correct and on or before 11/01/2023. 4. Subject to taking steps on the respondents as directed above, and his her appearance before the Superintendent of Police, Border, Borpeta, on or before 25/04/2024. Okay, numerate. For the records of such place this matter immediately for the admission, along with the connected ISC number 2518 of 2023.
Obliged.
Yes, Mr. Rasil, what is IA?
IA, my lord, your lordship passed order to granting bail, my lord, to everybody SP. And I obtained the copy, my lord. I approached before the advocate, my lord. Then advocate said, no, it will go, you have to go to the Baksha. Sorry, we went to the office, my lord, SP office, through an advocate. Advocate office said that it is the direct office. Now the case is parted to the Baksha. So I tried to go there, but they did not receive it, and because there was some delay in appearing there, my lord.
Now it is in Bojali or Baksha, because the
now-
order was
now-
passed by Bojali.
It is Baksha, but it is SP is under Baksha. I made a party earlier also, my lord, the same party, but your lordship passed order, there is a direction to appear before the SP Borpeta. That is the problem, my lord. The page, my lord, 10, your lordship may kindly see, my lord. In middle, as the petitioner has been declared to be a foreigner of post 1971 stream under the Foreigners Act 1946 by the impugned opinion judgment dated so-and-so passed by the learned member for instance of Borpeta and noted above shall she shall appear before the Superintendent of Police Border, Barpata. Actually, it should be, it would have been as a Baksha. I made party also in Baksha, but inadvertently that was there. But only Your Lordship is right, because the origin case is from Barpata. In order itself, it implies that the origin case is from Barpata. But in after that, the district has been bifurcated. Two district created, so there is a problem, Lord. So my prayer,
Just.
main reputation Millard, annexure 5, page 31.
Please take your seat. Come on. You mind if you do anything? Sure. No, Krishna, no. No. Take it now. Please. We need to-
No, now my instruction will not, it is in Baksha. My local advocate is there, Milord, and the party itself, Milord, says no. Then when it come on Friday, Milord, so that I can take another instruction, otherwise it will be again problem, Milord. But Milord, order, yes, why that is a Milord, you must be right. What is, an order is passed from, and case was originated from the SP Bogota border. And order passed by member. That's it.
No.
But
Add
these,
two lordship 60 meter at two, I will verify. Add two lordship 60 meter. Yes.
no, as per pin code Milord, you must be right, and sometimes in math Milord, I have, we can see same name, even some Uttar Pradesh names are coming, Milord, same name. Yes, for both district Borbata earlier Milord, but now my instruction, it is on Baksha.
All of them. Eight to seven. Record को पूरा से ताकि मुझे side line. Original বরপেটা আছে তো এই মিলিয়ে করে দিব পারি বরপেটা ইন্সপেক্টর করে দিব করতে
Order record নাই, record Baksha.
বাক্সার বাইরের লোক আছে
কোথায় বলে না?
বাক্সার এসপি
In our WS Milord, we also have mentioned our district Baksha.
add two lordship I can clarify lordship SP. Did not consider. And application of the like it. Yeah, I think that- there are the application. Where the code just be. Yes. It's. Applicant. But directly with peer. Before the concern. But the. Not before. Period and. The beginning of the.
Yes.
Lordship had heard it from the other day, Lordship. The respondents are not here, Lordship. 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 On that day, they submitted Lordship that the letter of 1998 will apply. That is. Lordship. Sir, page 31, Lordship. Lordship.
So, images of that approach was followed. I mean, in that figure, we have the reason for
Lordship. Yes, Lordship.
So there was no water available for you.
For
So that you are getting.
Lordship.
Absolutely.
Yes, Lordship. That was specifically pleaded before the cat also, Lordship.
But the tribunal did not consider.
Yes, Lordship.
But it's the order of the tribunal. That's page 112, I think.
Yes, Lordship, it's there.
113.
That portion.
What is the restriction?
That was not at all considered, Lordship, that point, Lordship, that it was not.
Page 14 of the order, page 114.
In order to ascertain,
This was provided to you to RBI. You should place in 45,
Lordship,
right? Let us.
paragraph 14, page 114. In order to ascertain whether there was some accommodation lying vacant / unoccupied due to lack of demand at the relevant period, we would refer to letter of the DGM so and so dated 3/5/2011 in reply to the RTA application dated 16/2/2011 submitted by the applicant seeking certain information. Against queries contained in paragraph 2 and 3, the replies furnished by the department are as follows. Number 2, how many type 4 bungalows in Maligaon area entitled to gazetted officers were lying vacant as on 25/9/2007? The reasons for remaining these bungalows vacant may please be furnished against each, including the bungalow numbers. Lordship, in the right hand side, list of bungalows lying vacant from the date given follows. Yeah. First one was lying vacant from 4/4/2008 to 8/4/2009. Then the second one was lying vacant from 2/1/2008. The third one was from 2/1/2008. Then the fourth one from 22/4/2006 to 7/7/2008. Lordship, then below are the ones which were there vacant, Lordship. The last two bottom at the bottom portion, Lordship, of that column. Lordship, although they say that that was what was before the tribunal lordship, but they had considered lordship. And otherwise, there were pleadings before the learned tribunal also with regard to this, that they were not fit for occupation lordship.
It is second, how long, how many times?
How many type four bungalows entitled for allotment to gazette officers were there in Maligaon area as on 25/9/2007? List of all these bungalows along with names and designations of the officers who were in occupation of these bungalows as on 25/9/2007 may please be furnished. The list of type four bungalows in PNO MLG area with occupants as on 25/9/2007 is attached as annexure 3.
Then exception video, okay,
Lodge. Right.
we annex you.
Yes, it was an explanation.
Page number 89,
Lordship.
page number 89. You have an A.
Annexure 3. It's not clear probably. Annexure 3 is there. 1 and 2 are there, lordship annexes.
Right?
Type 4, lordship. Mhm. Yeah, okay. What is the matter? Annexure 3. Okay. RTI replied with an annexure 3. तुम्हारे डॉक्यूमेंट नंबर
Please come to page 115.
Thus, from the above reply of the department, it is seen that there was a type 4 quarter lying vacant during the period in question. The applicant in the present case did not place the reply before the court, although the same was in reply to his RTI application dated 16/2/2011. Therefore, the stipulation under para 3 of the circular dated 9/5/2003, which was in operation at relevant time, will be applicable to the applicant's case for grant of HRA to him with effect from 14/7/2009. Moreover, the circumstances prevailing at the relevant time as communicated by the department by letter dated 3/5/2011 in reply to the applicant's RTI application dated 16/2/2011 corroborates the stand taken by the respondent authorities.
Let us see the 95 circular.
Page 61, my lord. Clause number 3.
How when
is the potential available? There are waters available. They could be that there are three.
But this won't come,
Maybe there are three.
this won't come in terms of their instruction itself, Lordship. That was, in case at any point of time it transpires that some accommodation is likely to remain vacant, unoccupied due to lack of demand, it should be made compulsory to submit applications for such types where there is surplus accommodation and consequently the employees entitled for such types would not be eligible to draw house rent allowance.
So, since you have not applied for the water. For the quantity, that you are having your house. And there are surplus accommodation. But that case will not affect you for your water.
Lordship, but at page 34, I had sought for house rent allowance on 27/9/2007, Lordship. At least they would have Lordship replied that I need to,
No, this particular type of water,
Lordship,
it was available for living with period.
During that period, for which?
but they did not say anything in the written statement before the learned.
You reply. You have to not for a reply, right? You have to reply. The earlier reply, what is it? So they available. Around 25/9/2007. And it is there for 25/9/2007. How will you make that?
Lordship may kindly peruse the office member and the letter of 88 once more, Lordship. Paragraph 3, 5, and 6, Lordship. At page 32. That is what they say that will apply, Lordship, not that of 2003, Lordship.
Mr. Mr.
Well,
61 that we have pointed out.
yes,
Inside
this 61 paragraph 3 of 61 is similar to what is there in paragraph 6 of the earlier 88 circular.
just 95/2003 that. Is valid up to 31st of March 2000. First paragraph.
No, this is something different. That is delegation of power. It is not that this circular. It is in respect of delegation of power, but what I would like to, the question of reviewing the this delegation powers.
Have you challenged this?
No, my lord. This circulars were not under challenge.
No, Lordship. Because Lordship, they themselves said that Lordship, this 88 will apply.
It's your claim. You are entitled for hospital allowance. If you become certain circulars will be released,
Lordship.
right? And that is why this circular was enforced.
Lordship.
And the tribunal found that there were available quarters, 5 full quarters. Which were attacked.
Lord.
Which you have not demanded. And as such, you are not entitled for the hospital.
There are two parts, my lord.
You would have been entitled for the hospital. Had there been.
No part.
Academic accommodation.
When you're vacating.
Lordship, those were vacant, but those were not, Lordship, fit for occupation, Lordship.
Should have applied. Then it was found in the unfit for accommodation. Then
That-
automatically, it was not possible for human habitation, you have rejected. Then the question of hospital allowance have come. Now, have you applied for it?
Not for accommodation, but for the house rent allowance. At least they would have said once, Lordship.
Who are there, you would have come to know. Should have, I expect, for it, maybe in a dilapidated property, or maybe someone.
But that was at a later point of time, Lordship.
Or they would have renovated for your purpose.
These RTI reply were furnished to me in 2009, Lordship.
That is the reason we try to.
But in 2007, I had applied, Lordship, for house rent allowance. At least they could have said at that point of time that you need to apply for it first. Otherwise, how would I know, Lordship?
Now, since they have not replied. We have applied for house accommodation. In
2007 itself.
No, he has never applied for
Yes, yes,
accommodation.
I-
He has applied for HR allowance, not accommodation. At accommodation,
They could have said, Lordship, that you won't be entitled to house rent allowance at that point of time, Lordship, because
and my lord, he was granted HRA with effect from 14/7/2009 because on 13/7, the last vacant quarter was allotted. So
no,
from
no, they
14
are taking two stands here, Lordship.
either you complete or let me complete.
So,
They are taking two stands here in Lordship. Lordship may kindly have a look at the written statement. Page 55, Lordship. Paragraph 5.
Paragraph 5, it is specifically said there are clear pleading, there were 4 types of type 4 bungalows lying vacant in Maligaon area. And the last type 4 bungalow amongst the 4 vacant bungalows was allotted on 14/7. Therefore, the applicant is entitled for grant of HRA with effect from 14/7, which was accordingly granted to him.
petitioner retired from service.
Yes,
He received that HRA in his return.
yes.
When did he retire?
2013 itself.
What is my lord, 2013? My lord, he received HRA with effect from 14/7/2009 till retirement. And the present writ petition or the matter before OA was with respect to his claim for HRA with effect from 21/90/2007 to 13/7/2009. That period it was rejected because of these reasons. And my lord, originally this writ petition was allowed earlier and direction, my lord, the direction was given to make the payment, and in review, there is an order that we should make the payment first and then the review was considered. And however, while disposing of the review application, there is an order that any payment made by railway to him pursuant to the earlier order will be subject to outcome of the writ petition, which your lordship is presently hearing.
Can you tell us what is the total amount that is left?
Paid.
The amount of house rent bidding that
That is from 21/9/2007 to that disputed part. My lord, that instruction. Because it was paid to him directly in his account in terms of the order passed in the review petition. My lord, that exact amount I need to take the instruction because
Wait. Wait,
my lord, what was that amount?
because you put in that particular chart. When I received the bank to them. 2009, 14, 7, 11. Also, the other, from 27, 2009, right?
Yes.
25th of September 2007. Almost for 2 years.
My lord, there are two parts. From 14/7/2009 till his retirement, he is entitled because there was no vacant quarter, we paid it. Then from the dispute is from 21/9/2007 to 13/7/2009. My lord, that amount, lordship, in that case, may take up it on Friday. Because we'll have to get, because in terms of the order in past in the review, we made the payment and there is an order that the payment has been made. He can also say because that payment was made to his account, transferred to his account.
Lordship will kindly,
Exactly, my lord. In that case, readily, I don't have that instruction and it will not be possible even to get the instruction in the second hour over telephone.
It was the chart. After that, they will calculate the pay. For 2 years.
Lordship may kindly pay.
It comes to around approximately 1.5 lakhs.
It cannot be possible for him to return the stage money or you cannot return that money properly. It's not.
Because
They hold them to them, yes, it's not. The order of
yes, because that liberty was given in the review petition.
in that case. the court may consider making the requirement.
Yes, that if my lord, if it comes from my lord, I can consent or I can tell my client to accept that. My lord, my lord, Friday.
Lordship, at page 67, paragraph 6, it is the written statement, second one, filed by the respondent number 3.
See, whatever it is, can the review whoever is circular?
Lordship,
Yeah, in the second quarter. Then why does it take from 2009?
that is here, Lordship.
Which paragraph?
There are 6, Lordship. Page 67, that with regard to the statement made in paragraph 4.4 and 5.1 of the original application, the answering respondents while denying the contentions made therein begs to state that Sri K.K. Sharma, AFA so-and-so, Maligaon, now Vigilance Officer, Maligaon, has submitted an appeal dated 27/9/2007 seeking grant of house rent allowance after surrendering his railway quarter number so-and-so at Nambari with effect from 21/9/2007. It is stated that at that relevant point of time, the applicant was entitled for type 4 bungalow in view of his pay scale. There were 4 type 4 bungalow lying vacant, and as per Railways Board Circular dated 9/5/2003, the applicant must apply for type 4 bungalow. In the event of not submitting application, he will not be entitled for HRA. Therefore, no HRA was allowed to the applicant at the relevant point of time. However, Office of the General Manager P. Maligaon issued circular dated 22/12/2008 contending that from the date of issue of the said circular, all quarters including optional quarters, a uniform principle will be followed that on vacation of quarter, HRA will be payable on occupation by the next incumbent. Although the applicant was not entitled for HRA in terms of Railway Board Circular dated 9/5/2003, for his non-submission of application against vacant type 4 bungalow, he has been granted HRA with effect from 14/7/2009 by virtue of the circular dated 22/12/2008, which is prospective in nature. There is another circular, Lordship, that is of 2008. That the page 70. Page 71, Lordship. Right copy. No. Simple one line, Lordship. From now on, all quarters, including optional quarters, a uniform principle will be followed that on vacation of quarter, HRA will be payable on occupation by the next incumbent.
Yes.
HRA is being payable on occupation by the next incumbent,
Lordship,
right? How do you explain
Lordship, he was
it?
occupying
HRA
it.
will be payable on occupation by the next incumbent. So
Lordship,
that quarter was vacant till
14/7.
it was occupied on 15/7. 2009, you have been paid on 14/7. In 14/7, it was right back in,
that is their stand, Lordship, but then
what is your stand? What is the RBI back? You have not annexed the annexation part of the RBI plan. The tribunal found it,
Lordship,
will never find the annexation of RBI plan, the annexation 1 and annexation 2. You look for annexation in your certificate. There is no reason to hide it.
no, Lordship. I shall get that, Lordship,
The tribunal has verified
maybe, Lordship.
that at 11 point of time, there was a vacant. The union side is in 2003 verification of the. We have not applied for your portal. You applied for HRA. How will you be affected? How? He actually knows whatever the petitioner says to you in submit. You're a court officer.
Lordship, that I understand. But then, Lordship, there is another contention of,
One circular says, if you got the light method. And apply. Not made available. And question of billing.
Lordship,
Subsequent. Circular.
Lordship,
Those quarters were vacant. In July. 2009. Because the final position. On 14th of July 2009, there was no such quarters, who you have not applied for,
Lordship, herein, Lordship,
for the quarters, but you have applied for HRA. So since 14/9/2007, there was no vacant one. The regulator is giving you the consent.
Lordship. Herein, my case is similar to one S. Sengupta, Lordship.
Or some order been wrongly passed or something, we are in between the cannot do that.
So, Lordship, at least they may clarify that, Lordship, how they paid it, Lordship.
You have not applied for it, comes from 95,000.
That is not applicable, Lordship, in terms of their communication itself, Lordship. 1988 will apply, Lordship. How, Lordship? Lordship,
So. As per that.
that 2003 never superseded.
As per 95, you are required to apply, which you have not applied for the college. Did you?
No,
Or you have applied for only HRA?
Lordship.
You are staying in your own house.
Yes, Lordship. That 1988 will apply, Lordship.
When the vacancy was available, Do not entertain
In-
not available.
That 2003 considers only that aspect, Lordship, whereas 1988 considers in case of those incumbents who did not apply also, Lordship. My case is covered under 1988 because I did not apply, Lordship.
That is the subsequent notification, subsequent circular of guidelines in 2003, which you have not challenged.
2003 did not supersede,
Right.
Lordship.
Friday.
Friday,
My lord, the entire amount or
something
monthly breakup?
within the account.
My lord.
At least it takes 5 minutes to complete it. The HL will come out. Friday, sure,
My lord.
prepare on the. As the code is connected to the. In fact, family. That's what it will do. The record is for. The council. Of the lion. Paying the petition. Giving the period from. 14. Seven.
No.
25/11/2007. 13/07. Or 12. The. Order.
In the review petition, my lord. Yes.
It is 01/12/2022. Review petition number 9 of 2022. In. Resolution number 1.
My lord. Lordship is fixing it on 12th.
Yes, sir. The council is making mention.
My lord.
Evan.
Please, your lordship, my lord, here we have challenged the ex parte order, my lord. It is at page 30 to 37, my lord. Here the petitioner also filed a miscellaneous application, but that was also rejected, my lord. Dismissed.
Expert.
Yes, my lord. So here, my prayer is that this matter may be remanded back so that the petitioner can, petitioner has got sufficient documents, my lord, in support of his case, my lord, to prove that he is not an illegal migrant from, my lord, Bangladesh, my lord. In this case, he has also filed his written statement, my lord. And here the government Gaupura was also examined, my lord, who has deposed in support of the petitioner, my lord. At page 23, my lord. My lord, may I read the deposition, my lord? Yes, ma'am. My lord, written statement. It is page 17, my lord. 12/11/2012, my lord. 11/2012, my lord. 2000 and page 20 is the deposition, my lord, of the petitioner. Page 21, 1/7/2013, my lord. Yes, my lord, 2013.
The order was passed.
The order was passed. It was passed on 19/9/2016, my lord.
From 1/7/2014 to 19/7/2014. How many days?
My lord, yes, my lord, the petitioner remained absent because his counsel did not inform him and he was also sick, my lord. That is why he sought time, my lord.
That is your,
Yes, ma'am.
here for the record. Yes, evidence of the from 1/7/2017, right?
Yes, my lord. Thirteen, my lord. He also filed adjournment petitions, my lord.
Okay. 28th of August 2013. The speak for argument. And- Next was 27th of September. And take it. 25th of November 2013. It's for argument. 18th of January 2014. The tribunals for this the legal statement and the other. So on 13th of March 2014, the speech for argument and the good council paid for time. Then the next day was 21st of April 2015. And 30th of May 2015. 13th of May 2014. Again time. Short for the 6th of 30th of June. Then goes on. Next is 30th of June 2014. 11th of June, 11th of August 2015. 18th of September 2014. 12th of November 2014. 12th of January 2015. We put down dates, that is why you are saying. 13th of March 2015. 18th of May 2015. 3rd of July 2015. 17th of August 2015. 7th of September 2015. 19th of September 2015, 21st of September 2015, 30th of October 2015, 26th of October, November 2015, 4th of December 2015, 9th of December 2015, 15th of December 2015, and then it was fixed on 27th of January 2015. On 27th of January, after the time was granted on the prayer and by the actual matter of the prayer of the constitution. On 27th of January 2016, If by the next day, the argument is not given by the council. Based on the argument, if I don't do the part, based on the policy, we're getting Equity council. By another sum, right? So the private will be the. On 15th of March, the master conference. Ready for it. And it's on 27th of. On 27th of. For another week. Now, on first of June 2016, after filing Hazira. After filing Hazira. The council is not happy. So on first of June 2016, I will read. Last time is given to the opposite party for argument. When he looks, the case will be further after hearing a and order will be passed. 2006 of 2016. On 6th of June 2016, opposite file 45. And the council again raised the on 28th of June 2016, again filed taking time. Same was also granted. On 29th of June 2016, the petitioner appeared with her advocate. Time was for how deviated the trial was from the specific order 1964 the time to be matters have to be decided. So it was fixed on 12th of the affair. On 12th of July 2016, the petitioner appeared. Praying for another day. That goes on. Very surprising. And up to 27th of July, up to 12th of July 2016, petitioner along with her advocate appeared. In her presence, case was fixed on 27th of July 2016. Since 2716, the petitioner remained law. So 27th of July 2016, the court observed that since 28th of August 2023, matter is fixed for argument. But both of the arguments are made. We leave on the part of the possibility. The court will definitely pass an order. During the argument. On 3rd of August, again the procedure may actually be registered. But luckily for you, stenographer are not able. So the tribunal has fixed the matter on 8th of August. 8th of August, again the already stated. So the matter was fixed again on 30th of August 2016 for necessary order. On 30th of August 2016, the petitioner even acted without any steps. The arguments of the LTP side were hard and it was fixed on 14th of September. On 14th of September, the procedure even action. The state and that is ending of the event. So it was fixed on and on 19th of September, these orders passed by the tribunal. From where we want to take an expert.
My lord, because of the fault of the council, the petitioner will not suffer. Because he did not, the petitioner has no, he is an illiterate person. He does not know the outcome of the, my lord.
It's a matter related to the foreigner And somebody.
And the adjournments were taken by the council, my lord.
How immediate is let's see. From 28th of August 2030, the tribunal grant the time the petitioner for argument. You have said the witness was examined on 1st of July 2030,
Yes, my lord.
right? And since then, where is 1st of July 2030? When the order was passed. After more than 3 years.
My lord, the petitioner is an illiterate person, my lord.
You have heard all this time the petitioner appeared. But the legal action is already states, complete form. 28th of June 2000.
So he was not properly instructed by his counsel. He does not know, he did not know the outcome. He's an illiterate person. He did not know the outcome, oh my lord,
He
of
was
such.
aware
a-
of the fact that our error is pending in public. And he did not even bother to know that case. What happened thereafter. After that order of 19th September 2016, they filed an application on the 2nd of February 2007. It was again rejected by the trial. Thereafter, you have filed a secretary.
So far as the merit of the case is concerned, my lord.
That question of it is not an expert order. Tribunal consider everything, only evidence that can be used. It's not that the tribunal did not consider all it. Matter of only for the argument stated.
So that is why my humble prayer is that
Taken care of in that particular law.
last chance may be given, my lord. It may be remanded back.
Illegality in the order. First of all, pending was the illegality in the order.
My lord, in fact, there is no illegality, my lord, so far as my lord, after my lord. At least, my lord, it may be remanded back.
They're not sitting here for any maintenance or other, they're sitting here. If you can show us that exercising such power is the book and constitution. It is not a case where we are not demanding that the matter. But when the council and the party for the 3 more than 3 years did not argue the matter. And remain subsequently remain absent. Wherever the proceedings sought for time, the council sought for the time, the tribunal was so lenient. Then get time. And the last 6-7 occasions, the petitioner may actually without any step. Then what do you expect? The tribunal.
My lord, the order was rightly passed, my lord, so that's so far as my lord.
You take it as a submission. So as to be ordered, where is it illegal? What is the expert report?
My lord, illegal to your lordship may kindly see the government Gaunpura has been examined. And he, my lord, your lordship may kindly see his deposition at page 23, my lord,
That's
page 23. Hekmat Ali is a resident of Saidoria. He has been casting his vote. The opposite party's grandfather, Muhammad, resides at village Puk Fatijar. Exhibit 1 is the certificate issued by me. Exhibit 1 is my signature thereon. Exhibit 2 is the voters list 1965 where names of Hekmat Ali. Hekmat Ali is the father of the petitioner and his father's name appeared. Case was registered against Sariful. He lives at Gorehagi at present. His brothers and sisters live under Saidoria. I have known Sariful since I became Gaunpura in the year. My lord, the vernacular is next page, my lord. I could not, my lord, it is illegible. The year is illegible at page 24, my lord, at the bottom. Sariful has been residing at village Gorehagi since 6-7 years. He has been casting vote. Hekmat Ali had cast his vote in the year 1970 also. Regia is Sariful's stepmother. And your lordship may kindly see the link between Sariful and Hekmat Ali, my lord, at page voters list, my lord. That is at page 27, my lord. Page 27 at page, that is voter list of 1965, my lord. Hekmat Ali is the petitioner's father and his father's name is Muhammad. Then your lordship may kindly see at page 28, my lord. 28 is the voter list of 1916. Here your lordship may kindly say Hekmat Ali, son of Muhammad Ali, and Shariful Islam, son of Hekmat Ali. This is the link between the petition and his of 2016, my lord, at page 29, my lord. 28 is the translated version. 29, my lord.
That was exhibit number.
Exhibit number.
It's nothing. You have a reader side.
Yes, my lord. This. Certified copies of public documents. Every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees therefore, together with a certificate written at the foot of such copy. That it is a true copy of such document or part thereof. As the case may be, and such certificate shall be dated and subscribed by other officer with his name and his official title, and shall be sealed whenever such officer is authorized by law or make use of a seal, and such copies to certify shall be called certified copies. My lord, signatures of the officials, my lord. And signatures on the components, my lord. The payment of legal fees, as the case may be, and such certificate dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by seal.
And date.
Yes, my lord. Of 1965, my lord. Page 27. Seal is there, my lord. Seal, signature, and
What is the name?
it's by Deputy Commissioner, Judge Electoral Officer, AC Bhuya, Nirbachan Nibandhan. Yes,
Who
ma'am.
has been certified?
Copies by the Deputy Commissioner, my lord.
Deputy Commissioner
And
what is the date of which it was issued by him? Is there any
the
date by him?
3/7/2017.
Compared.
Yes, my lord, compared and
Then what is the name of the deputy commissioner? It is there as per section 76 of the Revenue Act.
is not there, my lord. The seal is there, my lord, AC Bhuya.
That is always have to be there in public. The person authorized to issue the certified copy. It is there.
No, my lord. But there is the deposition of the Gaonhura, my lord. He is a government Gaonhura and he has also, my lord, deposed that the petitioner's father's name and his paternal grandfather's name is also reflected.
It is 22 and 23.
23 is my translated person.
On the other side.
Yes, yes, differently said, yeah, madam. So this is DW2, my lord. OPW2 is,
That's what the proceedings that we use to the link between the petitioner and.
yes, yes, my lord. This is OPW2, my lord. This is he's himself identified as Gaubra, and he's aged about 31 years. This point has to be noted, my lord. The Gaubra has deposed before the tribunal, and he is just 31 years of age.
34, okay?
As per translation, it is 31. Yes, 30, it should be 34, but in translation, it is shown as 31 years. He's 34 years, man. Ekmot, my name is Jairul Islam. My father's name is Let Sharm Ali. Okay. My house is at Moja Putajar. So, Ekmot Ali is a resident of Siberia. Hekmut Ali, Sotia,
Or something.
yes,
Or something like that.
yes.
Or Daga or something.
Hekmut Ali প্রতিপক্ষ শরীফুলের দাদা,
Whatever.
yes.
Like that. Not even Shah.
কোকা দেউতাক,
Muhammad.
মোহাম্মদ কোকা দেউতাক, মনরা কোক,
খুব ফাতিজুরত থাকে মোহাম্মদ
মোহাম্মদ কোকা দেউতাক. This part is not understandable, মানে কোক পাতা জোড়া থাকে, তাতে ফুট দিয়ে এক বিশু, বিশু সহি প্রদত্ত দুই, দুই 19 প্রদর্শক দুই উপস্থিত চনৰ একমত নাম আছে,
গোচৰ হৈছিল শৰীফুলৰ
পিতাকৰ প্ৰৱেশ, পিতাকৰ কোন নাম? Yes. Yes.
বৰ্তমান গড়ে হাগিত থাকে গড়ে হাগিত থাকে পাৰিদুৱাৰত তেওঁৰ ককাই ভাই ককাই ভাই খুব ফাতাজুলত থাকে
একমতৰ ভাই ককাই, yes, একমতৰ ভাই ককাই পোতাজোৰাত থাকে কিজানি
ফুটাজিত চাইদৰিয়াত
গাঁওবুঢ়া হোৱা 12 2009 9 yes, পদৰ পৰা দেউতাৰ পদকীয়া নেক্সট মেলত পেজ 25 পদকীয়া যোৱা 5-7 বছৰ মান হ'ল।
That is.
Yes. Yes. পৰা
আমাৰ গাঁৱত
আগৰ পৰাই আছে
আমাৰ
গাঁৱত yes 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 ma'am that will be more easier.
গাঁওবুঢ়া হোৱা 2007
2007 চনত yes 2007 চন
আমাৰ গাঁৱৰ
15 পৰা
দিনত আগৰ আমাৰ
19 চনৰ পৰা
মানে 2007 চনত 12 চনৰ পৰা this is 12 চনৰ পৰা next part is 2007 গাঁওবুঢ়া হোৱা 2007 12 চনৰ পৰা তেওঁলোক চৰিফুলক আমাৰ গাঁৱত আছে না চিনু 12 চনৰ পৰা চৰিফুলক চিনু
আৰু লগ পাওঁ নেকি কিবা
আমাৰ গাঁৱত
বাসিন্দা
yes আমাৰ গাঁৱত আমাৰ গাঁৱত নাই নেকি নাই
হয়তো বাসিন্দা নেকি এইটো
next name
নাৰ্ভি হয়তো যোৱা
এইটো ইমান চনৰ পৰা গড়ে হাগিত থাকে
বছৰমান
মানে
হল আছে
5 বছৰমান
গড়েহাগিলৈ
হল
যোৱা
আছে।
5-6 বছৰ মান হ'ল গড়েহাগিলৈ যোৱা 5-6 বছৰ মান হ'ল
বছৰমান হল
দেউতাকক মাকক
তাতে দূৰ
দেউতাক মাক
খুব
বাপেক মাক
বাপেক মাক খুব ফতিলজাৰত আছে
আছে
ভোট তাত দিছে
ভোট তাতে দিছে
হেকমত আলী
তাতে
তাত
দিছে
দিছে
হেকমত আলী 1970 চনতো
ভোট দিছে দৰখাস্তকাৰী আগৰ পৰাই আছে ৰেজিয়া
কেতিয়া
চৰিফুলৰ সতীয়া মাক
ৰেজিয়া this is
Stepmother,
ৰেজিয়া মাইলৰ
stepmother.
ৰেজিয়া is the stepmother
যদি word চলি
ৰেজিয়া
খাতুন ৰেজিয়া খাতুন
ৰেজিয়া জনাতন
নেছা।
নেছা
হা,
জনাত নেছা No?
Hotia mark.
Control.
Control exam 9.
Yes, প্রমাণপত্র দেখুন জন্য
Mojnul Haq,
দুটা কি
গড়ে হাগির লোক কি আছে?
গাঁও বুহার মইনুল হক
হুম।
গরিহাবির গাঁও বুহার
হুম।
রেজিয়া খাতুন না
before that, প্রমাণপত্র লিখা নাই। Before that, what is going to?
জন্মর probably this is not a জন্মর
There is a deposition of. Petitioner.
deposition is prior to that madam of petitioner DW 1715 Shariful Islam Ahmad Ali গড়িয়াহাগিত থকা 6 বছৰ হ'ল তাৰ আগতে বিশেষ তৰাজান খুব উটাপাৰা কোটালজাৰত
কোটালজার।
টকাৰ this is ককাৰ ঘৰ আছে আদি আছিল আমাৰ ককাৰ ঘৰ তাতে আছিল তাত থকাটো গোচৰ হয় তাত থাকোতে গোচৰ হয় পাৰাইডৰৰ পাছতো পাৰাইডৰৰ নামতো মোৰ কোনো মোৰ
দাদাৰ
দাদা
দাদাজনী লাগিছে হাইড্ৰবি
নিজে বুজিব লাগিছে
আছে রেজিয়া খাতুন
দাদার নাম ভোটার তালিকাত আছে। মোৰ কাকাৰ নাম ভোটাৰ তালিকাত আছে।
কাকার
নাম ভোটাৰ তালিকাত আছে।
তাত থকাতে গোচৰ হয়
ভোট দি আছে।
কাৰ নাম ভোটাৰ তালিকাত আছে ফাৰাজান
ভোট দি আছে।
ভোট দি আছে গড়ে থাকি নেকি গড়ে নেকি উন্নত তালিকাত নাই
গড়েহাগিত ভোটৰ তালিকাত
নাম নাই
নাম নাই।
গড়েহাগিটো কি আগৰ জেগাত আগৰ জেগাত
মানে গড়েহাগি পিছত
গড়েহাগিত ভোটাৰ তালিকাত নাম নাই সুন্দৰপুৰৰ খালি
কটালচাৰত ভোট দি আছে। গড়েহাগিত ভোটৰ তালিকাত নাম নাই।
সুন্দৰপুৰৰ তালিকাত নাম নাই কান্দাৰপাৰ ন কান্দাৰপাৰ
মোহাম্মদ আলী। Yes.
তালিকাত নাম নাই তাৰপিছত কান্দাৰপাৰা মহম্মদ আলী ককাই ভোট দিছে
উম।
মোৰ কি আছে এইটো
মোৰ মা ৰেজিয়া খাতুন। মোৰ
মা ৰেজিয়া খাতুন
ৰেজিয়া খাতুন মোৰ
মা নেকি ৰেজিয়া মোৰ সতীয়া মাৰ নাম জয়তনেছা ভোট দিছে গাঁওবুঢ়া আহিছে জন্মৰ প্ৰমাণ পত্ৰ নাই দাদা ককাই ভাই সকলো মৰিছে কৈছে
ককাই ভাই সকলো
জন্মৰ প্ৰমাণ পত্ৰ নাই ন
উম।
জন্মৰ প্ৰমাণ পত্ৰ নাই ককা
আহমেদ আলী
এইটো কি গেলাপাৰা
আহমেদ আলী
আছে ককাই ভাই সকলো মৰিছে মোৰ
জয়তুন্নেছা
ভাই ককাই
জয়তুন্নেছা মৰিছে মানে ৰেজিয়া বেগম আছে ৰেজিয়া সতীয়া মা জয়তুন্নেছা is his own mother. তেওঁ ভোট দিয়ে তাৰে ভোটাৰ তালিকাত
সকলো মৰিছে মোৰ ভাই ককাই 7জন নেকি মোৰ ভাই ককাই 7জন নেক্সট পেজটো ককাই ভাই সকলো মৰিছে বুলি কৈছে
মৰিছে বুলি কৈছে
মোৰ ককাই ভাই 7জন এই মই ভৱন চুকালা সমীৰ বিশ্বকমত Akbar, Mokar, Anayur, Sir Islam.
Where
My lord, your lordship might find the evidence across part of the DW1, my lord. জন্মর প্রমাণপত্র নাই, the last line. জন্মর প্রমাণপত্র নাই. This is probably Dada Kokka. itu কি বলে?
দেখি দাদার নাম।
এটা দিয়ে?
ও দাদার ভাই সকলো মৰিছে।
নাই, পুক, গোল, এটা
জাগাটোৰ নামটো এই যে জাগাটোৰ নাম আছিলে
গেগা পড়া নাকি?
পোক ফাটাল যাৰ।
তাও জানি।
পোক ফাটাল যাৰ।
Total jarot আছে. Next part, when the last line. Dadar kakar bhai সকলো মৰিছে, no? Kaka means father.
কাকা means
Grandfather. Kakar bhai সকলো মৰিছে.
মৰিছে। ভাই ককাই 7 জন।
মোৰ ভাই ককাই 7 জন। মই
এইবিলাক নাম বিলাক দিছে।
মই ফাৰ্ষ্টত মই 7 জনৰ পিছত মই, this is Koran, probably Pawan, Sunakul, Sajir,
তৰাফত নেকি চকমত।
Sokbor. This is Sokbor. Then Akbar.
আনোয়ার, সৈয়দ ইসলাম, সাইফুল ইসলাম।
Mokar Nikita, no? Mokar Nik Chokar. This is Mokar. Anusa,
কাকার দাদা আহমদ আলী নাকি?
Kaka লিখিছে নাকি? কাকার দাদা
মা জৈতুন্নেসা।
আহমেদ আলী। মা জৈতুন্নেসা হতে
আগতে মৰে নেকি আছে?
জৈতুন্নেসা
সতিয়া ৰেজিয়া জীৱিত। তেওঁ ভোট দিয়ে।
something nine, Talikat 9. Talika 9.
দাদাই মোক আনে নেকি আছে?
Okay. 25 years. 25 years. The tribunal has described page 32 in the opinion, probably that is DW1. this may helpful for, because so DW one, my lord, we may read once again, helping, taking the help of the tribunal's opinion, my lord. This is, this may be Gorehagi Toka 6 বছৰ হ'ল. For last 6 years, is residing in Gorehagi. তাৰ আগতেই ডেৰজন ন গাৰাজন তাৰ আগতে গৰাজন ফুটাজাৰৰ কাকাৰ ঘৰত আছিলো. কাকাৰ ঘৰত আছিলো. তাত থাকোতে গোচৰ হয়. This may be like this, my lord. তাত থাকোতে গোচৰ হয়. ফুটাজাৰত থাকোতে মোৰ ককাৰ নাম ভোটাৰ তালিকাত আছে. DW1 minute, first part. This will be like this, minute.
First line is Gorehagi Toka
6-7 বছৰ হ'ল. তাৰ আগতে, minute. গৰাজানত পূব ফুটাজাৰত কাকাৰ ঘৰ আছিল. তাত থাকোতে গোচৰ হয়. ফুটাজাৰত
পৰিবাৰৰ নামতো গোচৰ হয়. পৰিবাৰৰ নামতো পৰিবাৰৰ
তাত থাকোতে গোচৰ হয়, my lord. That is this second line. Right. Yes.
পৰিবাৰৰ নামতো
গোচৰ আছে. নামতো গোচৰ আছে. গোচৰ থকাৰ গোচৰ আছে. This is not পৰিবাৰ, my lord. This is Potaljar. ফুটাজাৰৰ
থাকোতে মোৰ কাকাৰ ভোটৰ তালিকাত
নামটো
আছে.
ফুটাজাৰৰ নামটো মোৰ কাকাৰ পৰিবাৰৰ পৰিবাৰৰ নামটো গোচৰ আছে. গোচৰ হ'ব. মোৰ নামতো
মোৰ কাকাৰ ডি ভোটাৰ তালিকাত আছে. কাকাৰ নাম
নেক্সট দেন দিছে ভোটাৰ তালিকাত আছে.
নাম আছে. ভোটাৰ তালিকাত আছে.
This is ফুটাজাৰৰ থাকোতে মোৰ কাকাৰ I am নেকি
নাম ভোটাৰ তালিকাত
আছে. The father's name is there in Patarjar. Patarjar. Kharjan.
Then
পাৰজনত
ভোট দি আছে।
ভোট দি আছে পাৰজনত টোটাল জাৰত ভোট দি আছে yes ভোটাৰ তালিকাত
নাম নাই।
নাম নাই কাণ্ডাৰ পৰা
মোহাম্মদ আলী ককাই ভোট দিছে
yes মোহাম্মদ আলী ককাই ভোট দিছে মোহাম্মদ আলী ককাই ভোট দিছে মোহাম্মদ আলী is the grandfather this is
মোৰ
মোৰ
নামো আছে।
মোৰ নামো আছে this is
2016.
মাৰ নাম ৰেজিয়া খাতুন
মাৰ নাম ৰেজিয়া খাতুন
মুৰতিয়া মা
ৰেজিয়া খাতুন
মাৰ নাম জয়তুন নেছা উপহি হাত
মোৰ সতীয়া মাৰ নাম জয়তুন নেছা বাইদেউ
নহয় মোৰ
মোৰ মা ৰেজিয়া খাতুন
yes
ৰেজিয়া খাতুন
মা
ফতিয়া
ৰেজিয়া
মা।
খাতুন
then মোৰ সতীয়া মা
মা সতীয়া মাৰ নাম মোৰ সতীয়া মাৰ নাম
ৰেজিয়া খাতুন ফতিয়া মা। মোৰ নিজা মাৰ নাম জয়তুন নেছা জয়তুন that is নিজা নে আপোন মাৰ
মোৰ নাম ৰেজিয়া খাতুন মোৰ মাৰ নাম মোৰ মা ৰেজিয়া খাতুন
ৰেজিয়া খাতুন মোৰ মা
সতীয়া
ফতিয়া
সতীয়া word is
Kotia is Regia Khatun is Kotia, my stepmother.
we cannot say can you just say more
It is written Kotia, Mur Kotia.
মোৰ মা
It
ৰেজিয়া
is underlined, my lord, Kotia.
then
Kotia ma. Mur.
this is সতীয়া
It is Mar Nam Joytun.
more সতীয়া মাৰ নাম
জয়তুন নেছা
Rupohi hat
ৰূপহীহঁতত
vote this.
ভোট দি আছে
Vote this.
মোৰ সতীয়া মাৰ নাম জয়তুন নেছা উপহি হাতৰ
ভোট দিছে বিদেশী নহয়
বিদেশী নহয়
গাঁওবুঢ়া আহিছে
গাঁওবুঢ়া আহিছে না আছিল
আহিছে
আছিল
then something প্ৰমাণ পত্ৰ নাই
জন্মৰ
my learned friend is saying মোৰ মাৰ মা ৰেজিয়া খাতুন here the one word my learned friend is saying Hotia ma this Hotia has been Hotia just before the Hotia মোৰ মা in the top mother above the Hotia মোৰ মা
মা ৰেজিয়া খাতুন
yes মোৰ মা Hotia is
here is
underlined above there it is written মোৰ মা
first line is মাৰ নাম
yes madam
মাৰ নাম ৰেজিয়া খাতুন
Rajia Khatun then Hotia word was there Hotia is underlined and above that it is again written more mother more ma then it is said
মোৰ নাম ৰেজিয়া খাতুন মোৰ সতীয়া মা
mar nam Joytonesa yes here it is again then more Hotia mar nam Joytonesa Rupimat Tatot Buddhi ase ভোট দিছে বিদেশী নহয় গাঁওবুঢ়া আহিছে that is his person
Then some common photo like props.
মোৰ জন্মৰ জন্মৰ প্ৰমাণপত্ৰ নাই। মোৰ what is not there, জন্মৰ প্ৰমাণপত্ৰ নাই। কাকা আগতে গোপালঝাৰত আছিল।
ককাৰ ভাই সকলো মৰিছিল।
ককাৰ ভাই সকলো মৰিছে।
ভাই ককাই
7জন। মই then it is ভৰণ probably ভৰণ or চৰণ
Then Sadir,
শুকুৰ ন
then
Shukal.
Shukpur.
চুকাল নেকি
The names are given.
সাদিৰ
And we say ভাই ককাই 7জন।
yes ma'am
মই এজন।
মই এজন
Sadi,
চকবৰ আকবৰ then বাকাৰ আনোৱাৰ সৈফুল ইছলাম আমাৰ কাকাৰ
Kakar Dada Ahmad Ali.
আমাৰ কাকা মোহাম্মদ আলী
Babar Baba Ahmad Ali niki? Niki.
আচ্ছা বাবার বাবা
মোহাম্মদ আলী।
মোহাম্মদ আলী মা জয়তনেছা হতে কৰে মা জয়তনেছা সৰুতে মৰে
Porute More. Potia Regia Jibito.
সতীয়া ৰেজিয়া জীৱিত
Teo
Teo?
Die.
ভোট দিয়ে 1970 চনত কাকাৰ ভোটাৰ তালিকাত নাই কাকাৰ ভোটাৰ তালিকা নাই
বুদ্ধি আছে।
কাকাই ভোট দি আছে নাজানে
Papa mane grandfather. Pokar.
Now let us read, my lord. This is from this. It is that his son of his grandson of Muhammad Ali. His mother is Joytonessa. Mother died when he was small or during childhood. The mother died. His stepmother is Regia. Regia is alive. She is casting vote. 1970 চনৰ তালিকাত কাকাৰ ভোটাৰ তালিকা নাই কাকাৰ ভোটাৰ তালিকা নাই দাদাই কাকাই ভোট দি আছে so now the Gaubra again Hekmat Ali Suryapar Kothar
Please come to page number 17, the written statement of the property. কর্তৃপক্ষের বিরুদ্ধে অগ্রগত কোনো কারণ অভাবে সুবিধাগুলো আর কোথাও স্থির হইতে এদিকে আইন 1943 ভিডিও অধিকার প্রাপ্ত বিজ্ঞানীরা অভিযোগ সময় আর ব্যক্তি সাধারণ নাগরিক সত্ত্বেও বাংলাদেশৰ পৰা ভাৰতত প্ৰৱেশ কৰি ধৰে ৰাখি আন্তঃঘটনা সদৰ জিলাৰ অসমত অবৈধভাৱে প্ৰৱেশ কৰি প্ৰকৃতি কৰে বুলি এনে অভিযোগ নহয় ভিত্তি কৰ্তৃপক্ষই কোনো বিদেশী নহয় কৰ্তৃপক্ষ ভাৰতীয় নাগৰিক সন্দেহৰ স্থলত নাই কৰ্তৃপক্ষ বিদেশ সন্দৰ্ভত পুলিচে সন্দেহৰ বশত কৰ্তৃপক্ষক বিদেশী সজাব বিচাৰিছে কৰ্তৃপক্ষৰ বিভিন্ন উদ্দেশ্য অসমৰ তালিকাত অসম বিধানসভাৰ উপজেলা সমষ্টি প্ৰকৃত কথা এই যে কৰ্তৃপক্ষই চলাচল কৰিবলৈ then they were reduced. Significant movement Nagaon জিলার অন্তর্গত গাঁও ও কোদালদারর মোজা সাইডরিয়া
থানার উপরিয়া
উপহিয়ার জিলা নগাঁও অসমৰ বসবাস কৰিছিল আৰু উক্ত স্থানত প্ৰতিজন্ম লাভ কৰিছিল। ঠিকানার প্রতিবিম্ব ভোটার তালিকার নাম আন্তর্ভুক্ত হয়েছে। প্রতিবিম্বর ভিত্তি এটিও জীবিত আর উচ্চ ঠাই প্রদান করিয়েছে। তেখেতৰ নাম হেকমত আলী আৰু হেকমত আলীৰ পিতৃৰ নাম মোহাম্মদ আলী। 1965 চন কিমান আমাৰ ভোটাৰ তালিকাত আন্তৰ্ভুক্ত হয়েছে। প্রতিবিম্বর নাম 2010 চনৰ ভোটার তালিকাত উপহিয়া আন্তর্ভুক্ত হয়েছে। প্রতিবিম্বর পিতৃৰ নামো 2010 চনৰ ভোটার তালিকাত আছে আৰু প্রতিবিম্বর উঠিয়াই কেঁচা নামো 2010 চনত ঠাই ভোটাৰ তালিকাত অন্তৰ্ভুক্ত হৈ আছে আৰু প্ৰতিপক্ষৰ পিতৃ মাতৃয়ে
ভোটদান
ভোটদান
কৰিছে।
কৰি আহিছে ও আছে, কিন্তু প্ৰতিপক্ষই উক্ত ঠাই এৰি জীৱিকাৰ বাবে ঘৰে আহি ৰাজহুৱা বসতি কৰিবলৈ নহয় আৰু বিয়া কৰি ঘৰ সংস্কাৰ কৰি স্থায়ীভাৱে বসতি কৰি আছে। প্ৰতিপক্ষৰ পিতৃ মহম্মদ হেকমত আলী পিতাই মহম্মদ ভোটাৰ তালিকা ভোটগ্ৰহণ কেন্দ্ৰৰ নম্বৰৰ নাম প্ৰতিপক্ষৰ পিতৃ মাতৃ নামৰ বিধানসভাৰ ভোটাৰ তালিকাত নিৰ্দিষ্ট হৈ আছে। গাঁও কোদালদাৰ ক্ৰমিক নম্বৰ 158 মাতৃ নম্বৰ পিতৃ মাতৃ আৰু প্ৰতিপক্ষৰ ক্ৰমে নিৰ্দিষ্ট হৈ আছে। এনে অস্থায়ী
প্ৰতিপক্ষ
প্ৰতিপক্ষ এজন ভাৰতীয় নাগৰিক। প্ৰতিপক্ষৰ জন্ম নগাঁও জিলা অন্তৰ্গত
WS
The provincial monthly revenue desa namun 2010 ঠাই ভোটাৰ তালিকাত অন্তৰ্ভুক্ত হৈ আছে আৰু প্ৰতিপক্ষৰ পিতৃ মাতৃয়ে ভোটদান কৰি আহিছে ও আছে। That means continuously voting.
Yes, that is
What we have seen from the
evidence.
that with mother the revenues are expired
Hmm.
while you are young.
He was young.
But his stepmother is still living, my lord.
There is no name of stepmother here.
Written is- Gaubura has contradicted with the matter statement of the DW. From the evidence, from the,
Where is the evidence in affidavit of the number?
no evidence in affidavit was given. So this is
Record which is- That's the reason why the council was asked to translate it. Deposition. Declare. The impossibility.
written statement.
It's a really deposition. Evidence and affidavit of the. Let me know what.
Yes, DW1.
Not there in the record.
Listen. No, madam, there is no evidence in affidavit, only the deposition. No evidence in it.
No evidence in evidence.
Yes. It took you one.
The certificate. The certificate, madam, it's a-
My lord,
it's a-
certificate,
Okay.
no, my lord. We have not annexed, my lord.
It is here, my lord. It's by Ziarul Islam, the certificate is issued. Sariful Islam. Here the Sorkari Gaumburhar Praman Patra, I'm reading, my lord. The national emblem is embossed in the top of the certificate.
In there you go there.
Yes, ma'am. And this certificate was issued on 28/1/2012.
Yes, I mean, you- What is the linkage? I've seen two different.
Here, my lord, we have relied on the linkage with the, my lord, petitioner with his father and grandfather. That is. My lord, father is Hekmat Ali,
All are good.
my lord.
We have two there. What this is regarding to. In a voter list of 1965, you are claiming that the name of one Hekmat Ali, son of Muhammad,
Muhammad,
from village to Pataldar existed, right?
yes, my lord.
Now that voter list, as you have seen, is not in terms of section 76 of the evidence, Act,
Yes,
first of all. Secondly, the records are here, you can just verify. The photocopy of 1965 voter list that you have annexed in this writ petition is not the same voter list that you have exhibited before the tribunal. This is of 3rd of July 2017, that is in the writ petition annexure photocopy, whereas it is of 2012 that you have placed before the tribunal.
yes.
And just turn that page, turn that page. You are very much aware whenever there is judicial stamp copy, there will be name, to whom it was issued. It has to be there in the non-judicial stamp paper,
Yes, my
whose name it was issued. Anybody's name indicated. There has to be a number, the person's name, is it there?
no, my lord.
Not there. You will not get. The reasons you are also aware why you will not get. Secondly, this is of 1965. What is the next voter list of Hekmat Ali that you have exhibited?
Hekmat Ali is
2016.
16, my lord.
So what happened to
In between-
1965 to 2016 of a Hekmat?
Yes, my lord, in between is not available.
It's not continuous process. It has to be named, have to be figured.
But as per the instruction received from the
Now,
petitioner,
if
these are available,
the-
my lord.
Petitioner is 31 in 2016. Where is his voter list of previous years? Where is his voter list of previous year?
My lord, as per instruction received from the petitioner, my lord, he has got some, my lord, voter lists with him, my lord, but, if he is given, my lord, opportunity, he would.
No, opportunity will not come here, ma'am. It is your case. The proceeding case, proceeding knows everything. Now, the proceeding in his written statement
At
have clearly
That
stated
time it
that
was
his
not
mother,
available.
Joyatun Nisa, his custom, his voter, her name is in the voter list. Says involved in the franchises, is casting her vote. So,
My lord, in the written statement, some lines are written, my lord, mechanically, my lord, common lines are there. But in the evidence, my lord, it has been,
Miss Chaudhary, can we go beyond the written statements? Can we?
evidence, my lord,
Because see, written statement is filed all on the basis of the knowledge of the proceeding. How can we go beyond the written statement?
the evidence are there, my
Now
lord.
just tell us how this linkage that Sariful Islam is the son of Hakmot Ali, whose name figured in the voter list of 1965. How you are connecting it?
My lord, in 2016 voter list, my lord, my lord. which
First
is
of all,
fine.
where is the
Ye-
voter list of
yes,
Hakmot
ma'am.
Ali from 1970 onwards?
I have not annexed, my lord.
Which
At that time
you
it was
have
not
not
available.
annexed is not there, was it before the tribunal?
He could not
Was it-
produce at that particular
That's
time.
right.
my lord.
Then if the petitioner could have, see, it is possible, the petitioner immediately thereafter or after the order of the tribunal, he received it, and he brought it to the notice of the tribunal.
So
But
he could have, my lord.
he hadn't brought the notice to the tribunal.
Mm.
Yes, Mr. Paik,
My lord, first
or
of
we'll
all,
come back at 2. Make your submission at 2. Give us the judgments of continuity of the voter list. And whatever you want to give, we'll see.
the petitioner has,
Just a minute. Wait for the- Yeah. Yes,
my lord, the petitioner has filed WS and also adduced evidence. And the evidence of Gambura in this case. So it is not a case of, my lord, expertise. It is a case in contest. And as your lordship has already
that
pointed,
Ms. Chaudhary has seen.
yes, my lord. So now in merit, my lord, if we go on merit, the petitioner in his WS, my lord, WS is filed on 12/11/2012, my lord. The WS is page 14, my lord, 1/4. We have already read the WS, my lord. From the WS, my lord, there is no mention about his date of birth of the petitioner. There is no mention of date of birth. There is no mentioning of any siblings, if any, of the petitioner. my lord. And as your lordship has seen, my lord, in WS, he has clearly said that his mother is Jaitun Nisa, and who is alive, and they're casting vote along with parent. And now, one of the next document he's relied, the next to that, he relied on 2 documents. One is 1966 voter list. And the next one is, my lord, the Gambura certificate, and Gambura was called to prove the document. The 66 voter list, my lord,
65 or 60?
65, page 27, my lord. 65 voter list is of Pope Khotaljar. One Hekmot Ali, son of Muhammad, aged about 42 years, has been enlisted as a voter in this 1965 voter list. Now, my lord, the previous question here is, my lord, simple question. We accepted one Hekmot Ali was there in 1965 in Pope Khotaljar. Now the petitioner has to prove, my lord, that this Hekmot Ali, who is son of Muhammad, aged about 42 years in 1965, and who was a resident of Pope Khotaljar, is the father of the petitioner, indeed, father of the petitioner. That must have been. Now, to prove this, my lord, he has produced one Gambura certificate. That Gambura certificate, your lordship has already seen it. It is the national emblem is embossed in the top of the certificate. And the Gambura was called to prove the death certificate. And Gambura, while appearing before the tribunal, my lord, he has contradicted the statement of the petition. In case of the because your lordship will find that your lordship may kindly produce the operative person, that is page 35, my lord. Page 34 may be kindly seen for the time being. Page 34, my lord. In the opinion. Now, when the deposition of both the OPs, OWs is considered, it is founded, OP1 Shariful Islam has stated that his own mother was Joyton Nessa, who died while he was child, and his stepmother is Razia Khatun, who is alive. Where that is in the evidence part, whereas as OPW2 has deposed the different and contradictory thing that Joyton is a stepmother of OP and Razia is his own mother, and that they are alive and casting votes. So this is the evidence of the both the mother, as we have read out, my lord. Apart from this, OPs has not said anything about the father as to whether he is alive or dead. But OPW2 has stated that the parents of the OP are alive. Apart from this, OP1 has stated that his parents used to cast food at Garzan, where OPW2 has stated that they reside in Pope Khotaljar. In this way, these are the discrepancies of both the statement of the DW1 and DW2. So, on the Gambura, though has appeared before the tribunal, he has given a statement, and from this statement, it is seen that the statements of DW1 and DW is contradictory. That is one part. Second part, Gambura, though appeared before the tribunal, he has not brought any record. He has not proved his document, that certificate, on the basis of his contemporaneous record, my lord. That has to be, a certificate has to be proved on the basis of contemporaneous record, my lord. No certificate can be proved orally, my lord. And one thing I have pointed out, my lord, what was the age of the Gambura? Age of the Gambura was 34 years in 2013 when he deposed. So if he deposed orally, and if it is, my lord, his on the basis of his personal knowledge, he cannot depose, my lord, the fact which were happened prior to his born. He was born sometime, if he is 34 years in 2013, he will be born in sometime in 1983-84, my lord.
79.
Yes. 79-89, yes. So by no means, my lord, he can give evidence of the fact which were existed prior to 71. So he cannot say his evidence to that effect cannot be accepted. And he has not stated, my lord, he has not given his evidence on the basis of some contemporaneous record. He has not given evidence on the basis of record. Had it been given on the basis of some record, my lord, it could have been accepted. So he has not given evidence on the basis of record. It is fully on his personal capacity. Now, my lord, this one, the Gaungura, the certificate itself. I just like to point out two things, my lord, and the petitioner, my lord, while adducing evidence, has exhibited the in fact, that is not that was produced the Gaungura certificate, which has national emblem. I just like to point out the citation of judgment of this honorable court, where it is said that the Gaungura document, Palu Das, it is WPC, my lord, WPC 1157 2018. This is reported also 1157 of 2018, my lord. Palu Das.
PHF.
Yes, FA, madam. FALU, Palu Das. Here in para 32, my lord. Para 32. I'm just reading that portion, my lord. After the tribunal had declared the petitioner to be foreigner, the Gaungura could not have issued the exhibit annexure 16. In that case, my lord, the Gaungura have issued a certificate even after the declaration of the petitioner as foreigner, my lord. This is serious misconduct on the part of the Gaungura, if indeed he had issued the said certificate. But that part, my lord, more serious is annexure 17, which is certificate issued by the Sri Lohit Das, Gaungura of Mandi village and dated so and so. In addition to being a post-decision certificate, what is striking about this document is to us that the state emblem of India at the top of the certificate. Central government had framed the state emblem of India regulation used rule 2017 in exercise of the powers conferred under section 11 of the state emblem India prohibition of improper use act 2005, regulating the use of the state emblem of India in official seal or sanitary. As per rule 6.1, the use of the emblem of official stationery should be restricted to the authorities specified in Schedule 1. Schedule 1 contains the list of constitutional and statutory authorities authorized to use the state emblem. A Gaungura is not included in the list of authorities as per Schedule 1. As per 10.1, Rule 10.1, no person other than this authorized shall use the emblem in any manner. So the Gaungura is not authorized to use the state emblem, and that makes the document itself inadmissible. So the Gaungura certificate, if we ignore the Gaungura certificate, if the Gaungura certificate is not admitted, my lord, as admissible evidence, then there is no other evidence at all to prove that petitioner is the son of, my lord, the Hikmat Ali of 1966. My lord, I just like to rely on another judgment of this honorable court. It is a different judgment, my lord. This is, my lord, WPC 2370 of 2023, my lord. This is written judgment.
2370.
Yes, my lord. 2370 of 2023. This decided on, my lord, 9/6/2023.
Relates to,
My lord, decided on 90, page 14, my lord.
that relates to.
Para 14. That relates to, my lord, the voter list. Whether the voter list, my lord, the name of the person whose name is appearing in the voter list of 1966, whether he is the father of the petitioner or not, that has to be proved by bringing some other materials, my lord. Mere showing a name in a particular voter list, it will not prove that he is the son of that person.
Is it Aziz Mia?
Yes, madam. Aziz Mia. Para 14, my lord, the observation. Para 14, my lord.
Yes.
Here it is observed, my lord. Para 14. We are constrained to observe that a mere claim by a suspected person, by referring to a voter list, claiming a person therein to be his father, is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voter list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials or the materials acceptable in law. So here is the case, my lord. The petitioner is claiming that Hekmat Ali of 1965 is my father. One person in the name of Hekmat Ali was appearing in the 1965 voter list. Now, the petitioner has to prove that Hekmat Ali is my father by bringing some other materials to substantiate that fact. That is not done. That is not done, my lord. And the third issue, my lord, here. The one Hekmat Ali was there in 1965. After 1965, his presence in India is not proof. My lord, a person who entered in India in between 1965 to 71, 66 to 71, my lord, even though we accept that they may be treated as they are foreigners of 66 to 71, their existence in India has to be proof. Continuous existence in India has to be proof. But in this case, my lord, what I have seen is voter list, his father, projected father is in the 1965. In that case, we accept that one Hekmat Ali was there in 1965, that his continuous presence was there or not. But in one of the case of this honorable court, my lord, in WPC, this is 2021, my lord, 21 GLT, my lord, 318. 2021 GLT 318, my lord.
2020-2021.
2020, my lord.
1 GLT
1
308.
318, my lord.
Alam Ali.
Yes, my lord. Yes, my lord. Alam Ali. There you will also find para 5, that is with regard to voter list. Whether to prove that the petitioner and the father and project and brothers and sisters, my lord, if they are para 5, your lordship may kindly see. Here is the case, my lord, the proceeding projected Musharraf, their names should have been in the, my lord, same voter list, and they should cast vote in the same place, my lord, unless and until their names are, my lord, appearing together, it cannot be accepted that they are from the same family and they are of the same relatives, they are relatives, my lord. So that view is taken here in this case, my lord, para 5. My lord. Yes. The proceedee projected one Musharraf alias Musuru,
Please take your seat.
a resident of Jaipur, so and so, Gorakhpur, Uttar Pradesh, as the grandfather whose name appeared in the voter list of 1965 of the same place. He possesses a plot of land at village so and so in erstwhile Darang district, presently district Bishwanath, Assam, executing registered sale with so and so, by exhibit A, where the permanently settled. Accordingly, he entered his name in the voter list of 1989 of the aforesaid village Diringa Pathar, by exhibit B, showing his age 70 years. Although proceedee projected one Manjur Ali, son of said Musharraf Ali, whose name appears in the voter list of 1989 as his father, he failed to explain the reason as to why the name of Musharraf did not appear together with the name of Manjur Ali in 1989 voter list. This itself creates a doubt as to the relationship as father and son. The DW1 proceedee started that his uncle, one Zakir, also come with his grandfather, so and so, Musharraf from Jaipur, Uttar Pradesh, number 2 Diring Pathar, where both of them settled. However, said Zakir, who is alive, was neither examined nor any document was exhibited, showing that said Zakir is the brother of the proceedee, projected father, Masnur Ali. So here in this case, my lord, if their names are not appearing together, it creates doubt. That is the position. Here in this case also, the petitioner and the father has never been listed together in single voter list. And yes, this is shifted from one place to another. Then again, my lord, one thing I would like to point out, my lord, the petitioner has produced a voter list of 2016 here in this petition, which cannot be accepted under statutory jurisdiction. Thus, I have, my lord, pointed out a number of occasions, the judgments are there of this honorable court. Only one more thing, my lord. 2016, the entire facts, if we see, my lord, the petitioner took numbers of occasions, times for several occasions in the tribunal from 2012 to 2016. And there is no document to link himself with the Hak Motali. Suddenly in 2016, he entered his name in the voter list in that village from where he has shifted. According to him, he shifted from that village to present village. And suddenly in 2016, his name is appearing along with that father, my lord, in that village. And as per this honorable court has, and yes, one judgment of this honorable court, it is said when there is a tribunal case pending before in the tribunal, his name cannot enter in the voter list. So voter list of 2016 entrance, the name where the petitioner's name is appearing, that itself is void, my lord. Even though we cannot accept it as a document here in the High Court, but if we accept also, it cannot be accepted as a valid document because the law has debarred the entry of the petitioner in the voter list if his name is, his case is pending in the tribunal. So case is pending from 2012. He knows it well. But his name is entering in the voter list in 2016. So it make itself, the voter list itself is void. This entry in the voter list itself is void. So that is the judgment of this corner. That judgment is 2000.
Actually, the citation is 2018 4 GLT 59. It is the name of the judgment is Government of Assam versus Mamaja Khatun and others.
2018 4 GLT.
18 4 GLT 59, page 59. It's a read appeal, Your Honor. It is appeal was filed against the judgment passed by the Honorable Single Bench in the WPC number 1334 of 2009. In the read appeal, this Honorable Court has upheld the judgment passed by the Honorable Single Bench, directing that if any proceeding is initiated against a person by the Superintendent of Police, that person should not be allowed to cast his vote and he should be marked DA.
2018 4 GLT.
Yes, Your Honor. Page 59.
No result.
The
2018.
18 years. I am giving the readable number is 114 of 2011. And the Monopatra citation I have the copy of the Monopatra. Monu stroke the CX.
No, we do not have Monopatra.
I have made. Readable number 114 of 2011.
Who is the other side? State of Assam is the appellant.
Yes, sir. Other side is Mameza Khatun. MAMEZA.
MAMEZA.
MEZA.
TOO or TEUN.
Even.
Jamila Khatun or Mameja?
Mameza Khatun.
Net 9. You have to review. Read appeal number
114.
14.
2011.
2011.
11. First point itself will worship the honorable division benches noting has made the observation what were the observation put
Para,
by-
para.
para 1 year. That is if I put it, this appeal has been filed against the order dated 23/3/2011 rendered by the learned single judge in writ petition number 154 of 2009, directing the respondents herein to carry out the following directions. Number one, the Election Commission of India shall ensure that the D-voters are not allowed to cast their vote. D-voters will also include the persons whose names are included in the electoral rolls, but their citizenship are in doubt or disputed, and whose cases are pending in various foreign tribunals. Number two, to facilitate the above exercise, the Superintendent of Police Board of all the districts shall collect names of such persons whose cases are pending in the foreign tribunal and furnish the same to the jurisdictional electoral election officer, public returning officer, towards ensuring that they are not allowed to cast their vote. All the concerned authorities will act in the matter promptly and to excuse and to exercise will be undertaken. They will bear in mind that their allegiance is to the Constitution of India and not to all the political process. Therefore, the direction should be carried out in working towards ensuring that such doubtful or disputed voters are not allowed to cast their votes in the ensuing election to the state. Any dereliction of duty towards implementation of the direction contained in this order would be viewed seriously. The officers concerned will bear in mind that such dereliction will result in initiation of departmental proceeding, including information of the proceeding of Article 11 of the Constitution. This observation has been upheld by this honorable division bench. Your Honor. But this judgment is direction given where, which para? No, the direction was all given by the single bench, Your Honor, which were salient in this read appeal, and this honorable court has upheld that the directions were rightly passed by the single bench.
Okay.
Apart from the Gambura certificate and Gambura evidence, there is no evidence at all to link himself to the projected father of the petitioner. And I have already indicated, my lord, Gambura certificate cannot be admissible in admissible documents. The Gambura has contradicted the statement of the my lord, the DW1. He has not proved the document on the basis of contemporaneous record. And last point, my lord, the Gambura is not authorized to issue certificates of such kind. Judgment to this effect, those points, my lord, there are numbers of judgments. And this is settled position. So if Gambura certificate is gone, there is no other evidence.
So Gambura is not authorized to issue certificate of linkage.
Yes, madam, the certificate of linkage.
You have the judgments which is.
That is Madam Kabir Khan. That is WPC 4271 of 2019, madam.
WPC
4271 of 2019.
Okay.
4271 of 2019, madam. There it is said, Gambura is not authorized to, my lord.
Which para?
There are 6 months. Last part. The observation is in last part. There are 6 last part.
Yes.
Fact, my lord, personal knowledge is certificate is issued on personal knowledge. That cannot be accepted. That cannot be accepted. That is also there, my lord, in the chief judge. And that certificate has to be, my lord, proof on the basis of continuous record. That is also there. So with regard to this Gawabra certificate, my lord, your lordship may kindly note down 4-5 points, my lord. First of all, Gawabra is embossed, the national emblem is embossed in the top of the Gawabra, so it is not admissible, first of all. Secondly, my lord, the Gawabra has not proved a document on the basis of contemporaneous record. Thirdly, my lord, Gawabra is not authorized to issue such kind of certificate under the executive instruction of the Assam Land and Revenue Regulation. My lord. Fourthly, my lord, the Gawabra has contradicted himself the statement of the my lord DW1. Fifthly, my lord, the Gawabra, who is aged about 34 years, my lord. Just 34 years in 2013. His personal knowledge cannot go beyond, my lord, at least 1980. So he has given an evidence of 1971, 66, that his father was there, father was casting vote. This cannot be accepted. Because he cannot have knowledge if he is a, my lord, personal knowledge, if he is giving in his personal capacity. His personal knowledge can at least be get from 1985, 86 onwards, because he's just 34 years in, my lord, 2013. So if he is 34 years in 2013, his date of birth will be sometime 1979, 80. And if he is born in 1979, my lord, his knowledge of understanding can be at least, suppose we accept it, he's there in from childhood. If he has some knowledge from his childhood, from 5 to 6 years also, he can get knowledge from 1985, 86 only. Not beyond that, but he is giving evidence that his father is casting vote in that village from 1965. That cannot be accepted. So he cannot have that knowledge. A person who is 34 years of age in 2013. So from all these few, the Gawabra evidence cannot be accepted in this case. And secondly, my lord, even though we accept that Gawabra being a person, being a reputed person or whatever, my lord, if he give a oral evidence, that oral evidence cannot be accepted in absence of documentary evidence to prove, to link the petitioner along with father. In absence of documentary evidence, there are numbers of judgments that I can produce.
Do one thing, Ms. Chaudhary and Mr. Pai, Mr. Ali, give a short written argument by Friday.
Yes.
Give it to us by Friday.
Only this point, sir. Okay. How
Give it to us by Friday, this matter will be said again. Give any time again. Order, Chaudhary, counsel appearing for the petition. And Mr. J. Pine, Standing Counsel, Home Department, Assam, for the response number 2, 3, and 4. As well as Mr. Fazarika, Advocate Assam, for the respondent number 5. Here is the records of FP case number 634/2011. Of the learned member for this tribunal, first Nagaon. That was called for. By order dated 06/11/17. But. Mr. Already counsel appearing for the petitioner. Mr. Deep and standing counsel in the court. Both. Shall submit your written argument. By 12/01/2024. List on 12/1.
My lord, this matter may be adjourned because I lost contact with the petitioner for the last 5 years, my lord.
When do you want?
My lord,
Tell us.
next month, my lord,
Next month,
yes, my. Yes, I'll try to contact my,
6th of February,
yes.
on the prayer of the council for the petitioner and as a child.
Please, your lordship. My lord, here in this case, my lord, there is an order dated 8/6/2023 asking my lord the standing council revenue development remain present, and on the next date, returnable date to obtain instruction as regard the computer generated print of the
Jamabandi
Jamabandi.
report, what to do with you?
my lord.
As the lineage, let us see, what is the matter about?
My lord, Jamabandi, my lord, she got land and she
Fine, we see to that, but there are judgment of the apex court regarding Jamabandi, you are aware. It is only matter, nothing to do with the citizenship of a particular person.
No, my
or
lord.
Nothing necessarily.
We are not only the relationship.
Hmm.
That Jamabandi, my lord, relates to, my lord, to prove of the linkage, my lord. Citizenship, my lord, that will, my lord, from the legacy document.
Let us see.
My lord, also, my lord, I want to see the records of the case. My lord.
You have not seen, you have been sitting here for morning.
My
By
lord,
this time you could have seen it.
my lord. Here in this case, my lord, father was examined and father is voter in 1966 onwards. My lord. So, my lord, father by
Which is
the
your link
evidence,
document?
my lord.
Which is your link document? Leaving aside that,
Linkage document, my lord, the evidence of the father and the land, my lord, Jamabandi copy.
no, just a minute. Have you annexed the written statement?
My lord. Annex 1.
Please take your seat.
My lord. My lord, may I go through the records, my lord, in the meantime, my lord.
Just a minute.
থাকক না ভাই দিছে তো একটা স্টেজ কিতাব পানিছে না ল্যান্ডলাইন রেকর্ড তো আমি তাতে ঝামেলাটা আছে এই মনিরুদ্দিন আহমেদ কি করবে মনিরুদ্দিনের জাজমেন্ট আছে হ্যালো আগে বলে ল্যান্ড ডকুমেন্ট মনিরুদ্দিন আহমেদ রিভিউ হুম তৈরি করে Muhyiddin Chaudhary, Nanga, Patri, here, Rosna Chaudhary. Muhyiddin Ahmed, Ordinance to It's good. So public interest now. Focus. Itu na ba ano? Ikon siya. Ikon siya. Ikon. Lagi tinggal ya. Raga. Not only 37. They were 37 3. Thirty-seven 3. It's like 5. 37 6. So we go to decision. Huh? Number size okay. Number. 2 1 A1 of 1 2. হায়দার আলীর কিছু দেশ হায়দার আলীর জাজমেন্ট হায়দার আলীর জাজমেন্ট আছে
But Mr. Associate Council appearing for the petition. And Mr. J. Bank, Standing Council Home Department. What are respondent numbers 2 and 4? Mr. R. Talukdar, Standing Council. Sorry, Government Advocate Assam. What is respondent number 3? AIL Standing Council, Election Commission of India, for respondent number 5. And Mr. J. Hendik, Standing Council. Revenue. Land Revenue and Disaster Management Department. Who appeared here, pursuant to the order. 806 to 2023. Mr. Speaker Council for the petitioner. Submitted that the matter he may be accommodated so that he can go through the records of the foreigners tribunal concerned in the original. Prayer allowed. Mr. Speaker Council appearing for petitioner may go to the records of the FT case number 8157/C of 2016. In original file, the interim order is 06/12/2017 was passed by learned member of Foreigners Tribunal number 1, Valpara, appointing the petitioner to be a foreigner under the Foreigners Act 1946. Entering the date of India on some honor of 25/03/1917. Such, and the petitioner shall peruse the records. State FT record. In presence of one of the Standing Council Home Department Assam. List of 11th. Bolo, recorded.
When?
11, day after tomorrow. We can go to the records, Mr. Pai.
My lord.
Ask someone to go through.
My lord.
Ecologically detail what we should make.
Yes.
No representation, we have the petitioner on call. The name of the two concerns have been reflected in the call list. List of the. And so we know vacation. On a date to be fixed by the registrar. Within the 11 record, the concern for an.
May I please, your lordship? My senior has gone to the dentist. So the matter may be taken after 2 weeks, your lordship.
Some prayer, the prayer of the council for the. And so the vacation, leave vacation. Within the 11 records, from the concern for respect. Of the concern for. One more.
Obliged, your lordship.
Well, please, your lordship. Lordship, may kindly peruse the order dated 11/8/2023. Baro.
May I please, your lordship. In this case, my lord, report was called for from the, my lord, SP border Borpeta, my lord, whether the petitioner Korimun Nessa and the name mentioned Korimun Nessa in voter list of 1966 and 1970 are same and one person.
That's irrelevant.
My lord.
That's irrelevant. The
My lord.
report cannot go through any such evidence at this stage,
My lord.
right? The order was passed. Anyway, we will not have anything to do with that.
My lord.
You have to prove your case. You have to tell us why that order is bad or good.
My lord, can you see the impugn order?
What is the link document?
My lord, this matter may be taken up another day, Mr.
Yes.
My lord, Mrs. D. Ghosh is appearing, may be taken up, she lakes in another court, my lord.
On the way of the council for the petition. List of. Now,
Highly obliged, your lordship.
they'll deliver. We'll take it up. Branching vacation. Mr. Singh, some other day.
Well.
Mr. Sharma, you are waiting for the bail. Take it up. Mr. In all the matters, fix it up for branching vacation, declare the conflict for the petition. We'll come back for the civil bench.
Lordships, still I appear, lordships. Some protection may please be given, lordships.
When this charge sheet was filed,
Lordship, CS number 448 dated Lordship 30/12/2023.
Heard Mr. Arsenal, counsel representing for the petitioner. And I'm the C. Begum, learned additional public prosecutor Assam for the state. Do you have a copy of the charge sheet with you or not?
Lordship, we have the copy, Lordship, but sections are not put here, Lordship.
Whether the petitioner has been.
That is not reflected, Lordship. They don't.
Petitioner is an FIR accused. In Ovaipuri Police Station, case number 343/2023. Registered under sections 406/4068/471 IPC. Corresponding to NGR number 613/2023. This is petitioners, please take your seats. Second, pre-arrest bail application. Inside Ovaipuri PS case number 343/2023. Earlier, petitioner preferred the similar pre-arrest bail application under section 438 CRPC. Seeking anticipatory bail inside Ovaipuri PS case number 343/2023. And this court, on perusal of the case diary, by order dated 26/10/2023, rejected his earlier file being AB number 3699/2023. And this court, on perusal of the case diary, by order dated 26/10/2023, rejected such pre-arrest bail of the petitioner. In AB number 3699/2023. Inside of our previous case number such and such. By order dated 21/12/2023, the court directed the learned public prosecutor, additional public prosecutor, to place the up-to-date case diary pertaining to site of our previous case number 343/2023. Ms. Begum, our additional public prosecutor, on instruction submitted that after investigating the matter, the authorities in the Ovaipuri police station right the Ovaipuri police station on 30/12/2023 submitted the charge sheet inside Ovaipuri PS case number 343/2023, wide charge sheet number 448/2023. In view of the above, the petitioner may approach the appropriate forum for his bail inside Ovaipuri PS case number such and such corresponding to NGR number such and such. If his name is incorporated in the said charge sheet number 448/2023. Needless to say, in the event of approach of the petitioner or his bail inside the where previous case number such and such. Public such and such, NGL case number such and such. The concerned court oblique forum shall consider the same in accordance with law. With the above observation, this pre-arrest bail application stands disposed of.